Hello everyone, welcome to Abhinish's show. I hope that you all have done well in your prelims examination, for which we have also uploaded the tentative or provisional answer key on our website. You can visit and download that and evaluate your answer keys. Most of the students have already done that and already have sent their objections or remarks regarding the tests which was held on 21st of May 2023. These are question was some questions were very patent from the Bare Act, some were very conceptual in nature, and with my all due respect and honorable submission uh, towards the OPSC, and some were also out of the box and to I think it is to test the nerve of the candidates. And anyhow, it went well, and those who have secured more than 35, don't lose your hope and kickstart preparation for mains examination, because there may be chances, there may be cases where the provisional answer key which we have provided and from you might have got it from any other sources might be faulty or in contravention with the OPSC answer keys, and due to the anomaly or other defects in the question paper, the grace marks is also awarded to the candidates, which ultimately make you get through this prelims examination without even premeditation. But that's what I want to say, that don't lose hope, and if you are in 35 to 40 bracket, you should uh, at least try to don't lose your preparation down and keep on preparing for mains examination. If it is 35 and above, there may be cases also that I have seen people, those who had secured 38 previously through various answer keys or their own answer keys. They stopped their preparation, but while the result came out, they easily got through the prelims, and hardly they were left with only 15 to 20 days to prepare for the mains examination, because the last 15 days will be taken by the anxiety attacks, that is for sure. So the productive 25 days is what you have left with. So without losing any hope, you start preparing from the very inception and start writing, and because this is the thing which will be helpful in your mains examination, because interview is only carrying 10 marks, 100 marks, and on an average students are scoring around 50 marks. So without any delay, start your preparation, and we are also providing to augment your learning and answer writing skill through our upcoming Agni Pariksha batch, details of which will be visible on your screen. For more details, you can call on to this number and visit our website also. Without any delay, you start preparing for those examinations or start practicing answers, and will there for you to take your preparation one step higher. So without any delay, let's start our today's discussion regarding the prelims answer key, because there are too many objections are coming and too many doubts in the mind of students, because those who are in the borderline, they might be losing their sleep because of that. So again, this is not a conclusive one, though a provisional or tentative one. That's why that's why we are also suggesting that don't let your mains preparation down. So today I am with me having the test booklet series A of 2022 prelims examination. Now the first question is regarding the constitution, which suggests that it is regarding the common name and case citation of each case. The first one is ADM Jabalpur case. This is also regarding the habeas corpus one, and MSM Sharma versus SK Sinha is regarding the searchlight case. A is option 2, B is option 4, C is RC Cooper versus Union of India is regarding the bank nationalization case. C is 3 and D is bearer and bond case. RK Garg versus Union of India. So the correct answer would be option D. Now question number 2. It is regarding Article 141, the doctrine of sacerdosis. That means the judgment of Supreme Court is binding upon all courts and works as a precedent. So that the judgment of Supreme Court is binding upon all courts. That all courts does not include Supreme Court. So the correct answer of this question would be option B. If you see that again a leading question or suggestive question being asked in question number 7, where it is being asked that this doctrine or this statement is implicit in which case law. Without any delay, let's have a look on question number 7. Question number 7 regarding the law declared by the Supreme Court is binding on all courts within the territory of India, but Supreme Court is not bound by its own decisions, was declared by the Supreme Court itself in option C, Bengal Immunity Company Limited versus State of Bihar. Now question number 3 is regarding Article 370. We all know that it is also a direct question, so I will not waste your much valuable time, and we will utilize our every second of each day for mains preparation. Now here as per section question number 3, the correct answer would be option D, I and 4th. Via public notification or via consulting with the state legislative assembly, the president can make the rule. Now question number 4 talks about right to life emanates from article 21 and includes right to die. This is also again a disputed question. Few students have their confusion in their mind that what is the correct answer of this question. For this you need to revisit the various Supreme Court judgments to this effect. First आसला पी रथिनाम वर्सेस यूनियन ऑफ इंडिया, तापर पी रथिनाम पर आसला जियान कौर वर्सेस स्टेट ऑफ पंजाब. पी रथिनाम रे कहला जे जो सेक्शन 309 ऑफ आईपीसी अच्छी दैट इज अनकॉन्स्टिट्यूशनल एंड राइट टू लाइफ इनक्लूड्स राइट टू डाई, जोटा कि ज्ञान कौर रे ओभररूल करागला आउ यह हेल्प कराला जे राइट टू लाइफ डज नॉट इक्वल राइट टू डाई. देन अरुणिमा सानबांग के पैसिव यूथेनेसिया केस आसला जोटी पैसिव यूथेनेसिया को अलाउ कराइथिला जे राइट टू डाई विथ डिग्निटी. And later on in the year 2018 in common cause versus Union of India सेठी पैसिव यूथेनेसिया को रिकॉग्नाइज कराइथिला आउ लिविंग विल कॉन्सेप्ट भी आसथिला. ए न्यू कॉन्सेप्ट ऑफ लिविंग विल हैज बीन इमर्ज्ड. तो सेठी कोन कहैथिला ना सेठी भी ए कहैथिला जे राइट टू डाई विथ डिग्निटी इज इंक्लूसिव इन राइट टू लाइफ अंडर आर्टिकल 21. सो सम मे misunderstood it that whether right to life includes right to die with dignity as well as right to die. But in the judgment of common cause versus Union of India in paragraph number 66, which I have mentioned in this detailed analysis paragraph, the PDF which will be, I will make sure that it is available in each WhatsApp group and the website itself, the link of which I will be given in the description box. Here it is given that in paragraph number 66, the right to die with dignity at the end of life is not to be confused or equated with the right to die an unnatural death curtailing the natural span of life. So right to life, right to die with dignity and right to die are also two different things and not to be equated. So the correct answer of this question number 4 would be the option A. Sorry, not the option A, it is option D. I will rectify it that it is option D, not option A. Question number 5 is, wait a minute. Yes, question number 5 is regarding that no person accused of an offence shall be compelled to be a witness against himself. Is an again this is also a direct question from article 20 clause 3, where it says that nobody can be a witness against himself or herself. Now question number 6. Emmanuel versus State of Kerala case is also known as, yes, this is a very famous case law that it talks about the national anthem case. Question number 7 we have discussed that. Question number 8 talks about that in which case it was held that taking specimen, wait a minute, yes, in which case it was held that taking specimen fingerprints and handwriting from accused is not hit by Article 23. Again, this is a very direct question. This is option A. Question number 9 talks about directive principle of state policy. Yes, this is for the governance of state, option D. Question number 10 talks about consider the following judgments delivered by Supreme Court of India. First is Ray Beruvari is the first in point of time, then Keswananda Bharati case. Recently we have observed the silver jubilee of this case, of this landmark judgment, for which Supreme Court has categorically and specifically dedicated a web page regarding the history and issues settled in this landmark judgment. We all know that the doctrine of basic structure, which is the backbone of our recent constitution, is also an outcome of this judgment. Now lastly, Excelware. So the correct answer of this question number 10 is D. First is 1960, then 1973, lastly 1978. Now question number 11. In which of the following cases the Supreme Court held that FIR was not substantive evidence and could only be used to corroborate its maker? Yes, it is again a direct question. The correct answer would be option B, that is C. Magesh versus State of Karnataka. Now question number 12 is regarding the dumb witness. It is again a direct question from section 119, option D. A court cannot compel the parties to undergo blood test to establish the legitimacy of child because it would amount to declaring the mother as unchaste and child as illegitimate. This view was laid down in which of the following cases? So the correct answer is the option D, Gautam Kundu versus State of West Bengal. Question number 14 talks about facts. Again, this is a direct question. This is regarding facts which are inconsistent and makes the fact in issue a relevant fact highly probable or improbable. So the correct answer is option C, section 11, which also talks about the plea of alibi under Indian Evidence Act. Question number 15 talks about mode of proof of a custom is contained in section 32.4, section 32.7 and section 48. The answer is D, all of the above. Now question number 16 talks about hearsay evidence becomes relevant when it is ratified by admission or confession. This means here I mean hearsay evidence is not acceptable or relevant in Evidence Act. Evidence must be direct in nature as per the Evidence Act, and एठी कहूची जे जदि गोटे हियरसे एविडेंस आसुची गोटे पार्टी एगेंस्ट रे आ से पार्टी ताको राटिफाई करूची माने ताको कंसेंट दउची किबा तिते राजी हे जाउची ताको एडमिशन करूची कि कन्फेस कर दउची से हियरसे एविडेंस को ताले सेटा भी रिलेवेंट हे जियो बोली ऑप्शन ए कहूची यस दिस इज आल्सो करेक्ट नाउ ऑप्शन बी टॉक्स अबाउट section 6 we all know that section 6 which talks about register is also an exception to hearsay rule. Thirdly, that when it is mentioned in any public document or is presumed by the court, it is also an exception. So the D is all of the above. D would be the correct answer. So question number 17 talks about under Indian Evidence Act 1872, a copy compared with a copy of a letter made by copying machine is a secondary evidence. This is question number 17. Option C is the correct answer. This is again a direct question from the Evidence Act, definition of Evidence Act. Now section question number 18 talks about the previous conviction is given under exception 2 of section 14. This is again also a direct question. Question number 19, this is the translation of this maxim. This is the correct answer would be option A of question number 19. Question number 20 talks about the right to private defense is available with respect to, this is available against the body and movable and immovable property both as per section 97 of IPC. This is the correct answer would be option D. Question number 21 talks about in which provision of Indian Penal Code the definition of valuable security is explained. Again, this is a very direct question. The correct answer would be option B, section 30. Question number 22 talks about the application of section 149 of IPC. Active participation of each person is required. No, being being a member of an unlawful assembly is also itself is an offence. So a person should be a member of unlawful assembly. Definitely, both A and B are correct. No, so the correct answer of question number 22 would be option B. And as per question number 23, this is a conceptual question where it is asked that X, a doctor informs his patient Y that he has cancer which is in its last stage. X requests Y to arrange his family affairs as he cannot survive for more than a couple of weeks. Y dies because of shock, and hearing this, X is that means जन डॉक्टर ता पेशेंट को कहूँ जे तुम पाखे बहुत कम टाइम अच्छी तुमको कैंसर है फाइनल स्टेज अच्छी एंड यू विल डाई वेरी सून. So this illustration is based on the principle laid down in section 93 of IPC, where the doctor commits no offence as the communication is made in good faith. So as per this, the correct option would be not guilty since communication was made in good faith for the benefit of Y. The correct option would be option B. Now question number 24. Again, this is a math question. Death is caused by safeguard property. We all know that private defense talks about the same thing. So A is with 4. Now death caused by a child of 6 years of age. Again, this is Dolin Capax 82. This is no offense. B is 3, option 3. Now C, death by an act with the intention of causing bodily injury which is sufficient ordinary to cause death. This is again a murder. C talks about 2. Now death of trespasser who of the house who was escaping. D is 1, because we all know that right of private defense while protecting the property. That means as long as the threat exists, you have the right to exercise the private defense. When the threat is removed, you have no authority to exercise such rights. So the trespasser of the house was escaping. That means the threat is no longer existing. So you are accessing your right of private defense in the superfluous amount. So that's why the protection of right of private defense should not be given. It will be treated as in excess of right of private defense. So it will definitely amount to culpable homicide. So this is the D is with 1. So the correct answer would be A4 B3. A4 B3, yes, D. So the correct answer of question number 24 would be D. Yes. Then 25. Question number 25 talks about which of the following is associated with common intention. Similar intention or same intention are not the part of this thing. The correct answer would be option B. Premeditated concert is a condition sine qua non to attract the principle of common intention. It was in Catena of judgments was reiterated by Supreme Court that pre-concert and premeditated concert of minds are prerequisite to attract the principle of common intention. Question number 26 is regarding X and Y agree to commit theft in Z's house, but no theft is actually committed. They are guilty of. We all know that when two persons agree to do or cause to be done, an offense it is for an illegal act or for offense no overt act is necessary. Mere agreement would suffice. So it would amount to criminal conspiracy, which is given under section 120A of IPC. Now question number 27 talks about the distinction between section 299 and section 300 was first elaborately discussed in the case of Reg versus Govinda. Now question number 28, this is somehow a printing mistake. You will be given benefit of this question. That's why I was talking about at the very inception of this video. There are some unwanted mistakes available in this question paper for which all of us will be awarded some marks, or it will stand not valued. We don't know what is the approach of the OPSC in this matter. but we should not lose hope that and should remain optimistic regarding this. We maybe get some benefit by the commission. Now question number 29 talks about every state government in coordination with the central government shall formulate victim compensation scheme. Again, this is a leading question. This is also a leading question and suggestive question, that obviously if it is in effect from 2009, it has to be based on 2008 amendment, or which is very nearer or in close proximity of the date of enforcement. So the correct answer to this question would be option A of question number 29. Now question number 30 is regarding the person seeking suspension of conviction should specifically draw the attention of the appellate court to the consequences that may arise if the conviction is not stayed, or yes, as held by the Supreme Court in, again this is a direct question, Navjot Singh Sindhu versus State of Punjab. This is also a famous question. If you know, you know. Now question number 31. When there is a dispute between two courts relating to exercise of jurisdiction in a criminal matter and state courts are under subordination of different high courts, the matter shall be decided under section 186 of CRPC. By those who are not aware of this section 186, they had probably gone through opted for this option A, but the correct answer of this question would be option D. Question number 31, the correct option would be option D. Again, question number 32 talks about, again this is a very direct question, warrant case means the term exceeding 2 years. So as per question number 32, the correct option would be, yes, option B. Now question number 33. An arrested person has a right to consult a legal practitioner of his choice. The constitution, the consultation with the lawyer, again this is nowhere directly mentioned, but we can apply our prudence, and this is a matter of prudence and a common sense, and the correct answer based upon these options would be first may not be in presence, and for 33 it is option D. Both A and B are okay. Both A and B are correct. Now question number 34 talks about, this is a lengthy one. Okay, let me get rid of this pop-up. Yes, in cases of consecutive sentences on conviction of several offences at one trial by a metropolitan magistrate, mind this phrase, metropolitan magistrate, the aggregate punishment. Before our prelims examination in our legal update series, the aspirants amicus series, I had categorically held this provision in detail, the link of which I will give in the description box as well as the info card. So you can directly watch it there. It is a very important video in which I was discussing the contours of section 31 subsection 2 and the famous leading landmark judgment of the Muthura Ramalingam case, where it was held that the such magistrate cannot exercise the power beyond twice of the power given under section 29. So the correct answer to this question 34 is option A as per section 31 subsection 2 of CRPC. Now question number 35 talks about period of limitation of filing claims and objections to the attachment of any property attached under section 83 of CRPC by any person other than the proclaimed person as provided under section 84. It is 6 months. 6 months of attachment, within 6 months of attachment, option B would be the correct answer. Now question number 36 talks about 91 CRPC, person who is summoned to produce a document on appearance before the court. जो लोक को डका है कोर्ट रे किसी डॉक्यूमेंट प्रोड्यूस करने जस्ट बिकज से गोटे डॉक्यूमेंट प्रोड्यूस करुच्ची ता माने नुह जे सी गोटे विटनेस हो बोली. अच्छा विटनेस हेनी माने आम तार क्रॉस एग्जामिनेशन भी करें कि री एग्जामिनेशन भी करें तो से এটা সেকশন 91 রে भी मेंशन हैनी सेक्शन 139 ऑफ एविडेंस एक्ट एटा मेंशन कराई जे एठी से कहई जे से पर्सन जे जस्ट बिकॉज डॉक्यूमेंट प्रोड्यूस करची ही विल नॉट बी ट्रीटेड एज ए विटनेस एंड क्रॉस एग्जामिनेशन ऑफ सच विटनेस कैन नॉट बी डन सो द करेक्ट ऑप्शन ऑफ दिस क्वेश्चन नंबर 36 इज ऑप्शन बी क्वेश्चन नंबर 37 कहला ऑब्जेक्शन टू द अटैचमेंट ऑफ ए प्रॉपर्टी इन एग्जीक्यूशन can be raised by the parties to the suit, by the stranger, third party, both, none of this. This is both. जदि को थर्ड पार्टी प्रॉपर्टी भी जे इंटरेस्टेड से प्रॉपर्टी दो नॉट ए पार्टी टू द सूट जदि किसी इंटरेस्ट भी अच्छी आम अटैच कर दौचु तो विदाउट हियरिंग हिम पासिंग एनी जजमेंट it is also it will be turn out to be injustice and it will be definitely against the principle of natural justice, though there are express provisions in CPC and CRPC as well, but principle basing upon the principle of natural justice also it can be sense that option C would be the correct answer. Question number 38 talks about after dismissal of the suit under order 9 rule 8 of CPC a fresh suit on the same cause of action under order 9 rule 9 of CPC is barred, it is expressly barred. Question number 39 talks about for the application of the principle of res sub judice which of the following is essential. Suits between the same party दुई जन पार्टी भितर सुट होता दरकार आ दुईटा सुट पेंडिंग होता दरकार आउ मैटर इन इश्यू इज डायरेक्टली एंड सब्सटेंशियली सेम होता दरकार बोली कहला तो द करेक्ट आंसर वुड बी ऑप्शन डी. It is a valid these are the valid requisite conditions given under section 10 of CPC. So now question number 40 talks about on default in filing the written statement under order 8 pronouncement of judgment is, though this is again a very confusing question which the aspirants faced during the examination, still now there is a common misconception that the answer would be mandatory because it would a shall word use कराई यदि ऑर्डर 8 रूल 10 आपण पढ़े से शाल वर्डटा यूज कराई बट सुप्रीम कोर्ट इन सलीम बार एसोसिएशन वर्सेस यूनियन ऑफ इंडिया 2003 या कहुई जे दो से शाल वर्डटा व्यवहार कराई डॉक्ट्रिन ऑफ हार्मोनियस कंस्ट्रक्शन विल बी अप्लाइड एंड इट विल बी कंस्ट्रूड एज ए डिस्क्रिशनरी वन नॉट मैंडेटरी वन सो द करेक्ट ऑप्शन टू दिस क्वेश्चन वुड बी ऑप्शन बी. Again before in our legal update series when the first law commission the recent law commission's first report was regarding to current the immediate amendment of CRPC and CPC criminal law things and procedural law things जहाँ पर गोटे एक्सप्रेस वीडियो भी मुझे बनई जार लिंक आई विल गिव द लिंक ऑफ द वीडियो इन द डिस्क्रिप्शन बॉक्स एज वेल एज द इन्फो कार्ड यू कैन चेक ऑन दैट. दिस इज ए वेरी इंपोर्टेंट केस लॉ एंड ऑल्सो ए वेरी इंपोर्टेंट वीडियो गो एंड हैव ए लुक ऑन दैट जो मुझे सलीम बार एडवोकेट एसोसिएशन इज ए वेरी इंपोर्टेंट केस लॉ जहाँ को आप एज ए लॉ स्टूडेंट वी शुड अवेयर ऑफ दिस केस लॉ जो थ्री कि ये प्रिलिम्स एग्जामिनेशन नहीं ये सलीम बार एडवोकेट एसोसिएशन पर दुईटा ही क्वेश्चन आसी दुईटा क्वेश्चन पड़े आसी केस लॉ उपर फास्ट तो आसला यहाँ क्वेश्चन नंबर 40 एंड अनदर वन इज आई एम टेलिंग यू अनदर वन ओके विल yes question number 44 question number 44 and question number 40 ये दीटा क्वेश्चन सलीम बार एडवोकेट एसोसिएशन ऊपर आसी एज ए लॉ स्टूडेंट वी ऑल्सो दिस इज एज 42nd amendment is a mini constitution like this सलीम बार एडवोकेट एसोसिएशन is also a mini CPC in its nature. So we all know we should all know this case law because there is two questions from this particular case law. So this is a discretionary one because it is categorically held that the word shall doctrine of harmonious construction should be given to order 8 rule 1 and rule 10. So the correct answer would be option D. The details I have given in the PDF, you can refer to that. Question number 41 talks about section 114 of CPC review is maintainable when appeal is provided and no appeal is preferred. Yes, true. When no appeal is provided, both neither. The correct answer would be option C. Question number 42 talks about in which of the following cases it was held that the second appeal is permissible only if finding is perverse. So as per question number 42, this is also a direct question. The correct answer would be Dinesh Kumar, option A. Question number 43 talks about under which provisions of CPC the court has jurisdiction to reject the plaint which does not disclose a cause of action. Again, this is also a direct question from Order 7 Rule 11. Correct answer would be option A. Question number 44, we have discussed that option A would be the correct answer. The constitutional validity of 2002 amendment was held in Salim Advocate Bar Association case. Question number 45 talks about that section 100A substituted by CPC 2002 amendment will not have a retrospective effect. This was held in Kamala Devi's case. Kamala Devi versus Kushal Kumar. Option D would be the correct answer. Now question number 46 is regarding share household. Share household is directly given under section 2S. Now 47. Question number 47 again a case law based question. The correct answer would be option A and option C. Both can be the answer. Now question number 48 talks about in the protection of domestic violence includes economic, sexual, both. The option C would be the correct answer. Question number 49, where a protection officer fails to discharge his duties as directed by the magistrate without any sufficient cause, there he shall be liable to be punished with imprisonment as well as fine or with both. This is as per section 33 of PWDV Act. Now question number 50, this is again to match a very factual question. The correct answer would be option A. Now question number 51 talks about when did the Domestic Violence Act came into force. This is 26th October 2006. Option D. Question number 52 talks about notice under section 12 is given to the protection officer. This is also given under section 13 of PWD Act. The question number 53 talks about child under protection. Child means all of the above. So option D as per section 2B, I think. Yes, 2B of PWD Act. Question number 54, breach of protection order under 3132 shall be an offence which is cognizable and non-bailable. Option B is the correct answer. Now protection of women from Domestic Violence Act 2005 derives its support from dash of the Constitution of India. This is again given the correct answer would be option B. This is a direct question which was asked in our mock test batch. Now question number 56. Section 6 of the Limitation Act does not apply in case of suits, execution of a decree, appeal, suit and execution of a decree. The correct answer would be option C. If you closely read the option the section 6, you will find that it is not applicable to appeals. Question number 57. Section 5 of Limitation Act applies for condonation of delay to apply this provision. Section 5 talks about the sufficient cause. Sufficient cause means it is not the quantity or the duration of the delay, but the justified delay should matter. So the correct answer, the length does not matter. If you are suffering from legal disability, though it may be 18 years or 16 years, you will be condoned. It will be condoned. But irrespective of the delay, irrespective of the length, your reasoning should be sufficiently explained in nature. But here the correct answer of this question would be, as per question number 57, is B. Length of the delay does not matter. As I told you, acceptability of the explanation is the only criteria. Now question number 58, for a term loan the period of limitation is 3 years from that. This is again a very conceptual question, that due date of payment of each instrument. Option C would be the correct answer. 59 talks about the fraud is contemplated by section 17 is that. Again, this is also a very direct question. If you go through the section 17 of the Limitation Act, you will find that option B is the correct answer. Question number 60. Under the law of limitations, suits can be filed within 3 years in cases relating to accounts, contracts, declaration, all of these above. For all of them, the period of limitation is 3 years. Question number 61 talks about section 11 of Limitation Act deals with foreign contracts. Option A would be the correct answer. Second appeal to Central Public Information Officer before Central Information Commissioner can be filed within. This is actually a out of syllabus question. Those who have a practice experience in the RTI Act, with the RTI Act, they can easily tell that option A would be the correct answer. In nowhere in the Articles of Limitation Act is this given, but it is given under the RTI Act. This can be challenged or probably be scrapped down by the on OPSC with my with all due respectful submission. That let's see, all I can pray for your good marks and hope for the best. Now, question number 63 talks about time limit for filing application to become legal representative due to death of a defendant or respondent. It is option B, 90 days. As per Article 120, I think. Question number, yes, Article 120, it is 90 days. Option B would be the correct answer. Temporary injunction may be granted to restrain the disposition from the property. Option B would be the correct answer. 65 talks about which of the following can be transferred under the provision of the Transfer of Property Act. This is a decree for mean property can be transferred. Option B would be the correct answer. 66 talks about which of the following can be considered implied surrender of the lease, the abandonment of possession by the lease. Now, question number 67 is under the provisions of TP Act, the seller is duty bound to disclose patent defect or latent defect. This is again the latent defect. Option B is the correct answer. Now, question number 68, under the provisions of TP Act, the benefit of a contract can be assigned as an actionable claim. As per question number 68, the correct answer would be option C, either A or B. 69 talks about under the Transfer of Property Act, vested interest is neither D. 69D, it cannot be defeated by date of either transfer or transferred because it is vested in nature. Now, question number 70 talks about, again this is a very direct question, the interest would be 9% per annum. Option B. Question number 71 talks about where the mortgage is illegal for want of registration but the mortgage continues in possession of the mortgage property. A valid mortgage comes in existence after the expiry of. This is again, I think this is somehow a dicey question. The answer to this question would be option C, but we have a contrary view regarding this question is that with my all due honorable submission, I want to reserve my view that this was from a repeal provision, namely Article 144 or 148 of the old Limitation Act. Now it has been repealed. एथिपाई राजस्थान हाईकोर्ट भी जजमेंट रही ओडिशा हाईकोर्ट ऑनरेबल ओडिशा हाईकोर्ट जजमेंट रही नेमली पुरुषोत्तम दास वर्सेस SM D'Souza AR 1950 ओडिशा 213 AR 1950 213 जो कहला कि जदि मॉर्गेज डीडटा भी अनरेजिस्टर्ड अच्छी आउ सब्सिक्वेंटली जदि से 12 वर्ष पोजिशन रही आसुची ताले सेटा गोटे राइट क्रिएट कर दउची बोली एमती ऑनरेबल ओडिशा हाईकोर्ट एटा हेल्प करथिले जोटा कि वेरियस हाईकोर्ट मध्य सेटा हेल्प करछंती किंतु द प्रोविजन नेसेसरी प्रोविजंस वर रिपील्ड I think this should be scrapped but can't say regarding this, but the correct answer would be option C. A little explanation to this question is that we can take an example. जदि गोटे मॉर्गेज होची आउ मॉर्गेजर मॉर्गेज को लॉ मैंडेट करछ एज पर सेक्शन 59 इट इज मैंडेटरी दैट इट शुड बी रजिस्टर्ड बट इट इज नॉट डन सो जदि रजिस्टर्ड होनी एडवर्स पोजीशन पे आमे जानिछु जे ओनरशिप को तमे डिस्प्यूट करछा दरकार ओनरशिप को ही तमे इनवैलिडेट करिया दरकार फ्रॉम द डे 1 किंतु तमे डे 1 ही एज ए मॉर्गेज रहउछो केटी ओनरशिप को तो आमे किसी डिस्प्यूटिंग करूनु तो ये गोटे कंट्रारी व्यू निया होता जे यहाँ डिस्प्यूट आसाला गोटे इश्यू थिला जे जदि आम गोटे कंट्रारी व्यू नेउना कि आज ए मॉर्गेज ही आम रही आसुँ आम ओनरशिप तो डिस्पोज कर माने डिस्प्यूट किसी करूँ तो एडवर्स पोजिशन केमिति हम तो लिमिटेशन एक्ट हाउ ए लिमिटेशन एक्ट वुड ओवरराइड दिस Transfer of Property Act. But in this case it was settled that जदि गोटे एक्टा गोटे मर्गेज डिड हो कि सेल डिड हो जब से रेजिस्ट्रेशन हो ना ता माने या हो से सेल डिड कि मर्गेज डिड एक्जिस्टिंग करूना दैट इज वॉइड. सो यदि 12 वर्ष से रही आसुची गोटे कंटिन्यूअस पोजीशन ने ताहले एडवर्स बाय वर्च्यू ऑफ दिस एडवर्स पोजीशन और आर्टिकल 144 148 previously what happened that 144 142 was in derogation with article 464 and 65. That is the reason why due to this anomaly article 142 and 144 was struck off. So this is a different story. I will take up in another video regarding this question, but for now I am reserving this answer with option C. Question number 72 is regarding which of the following are valid illustrations of an anomalous mortgage. This is option B. If you go through the mortgage provisions, you will easily find out that. Question number 73 talks about which of the following instruments have been excluded by the application of section 137 of Transfer of Property Act. 137 directly लिखा है sale, bill of exchange, neither of as per section question number 43, both A and C, the share and bill of exchange were excluded from the purview of section 137. Now question number 74 talks about in which of the following cases the doctrine of supervening impossibility will apply. This is again a very conceptual question, and those who have a very good command over this Contract Act, we can easily tell that as per section 56 of Indian Contract Act, you will get to know that option C would be the correct answer, and a proper explanation I have given in the PDF. You please go through that. Question number 75 talks about under which of the following conditions can a proposal be revoked according to the Indian Contract Act. As per the correct answer of this would be yes, this can be yes, option C would be the correct answer. Section 6 you can refer to that of Indian Contract Act. Now 76, a contract of agency implied in the agency may arise by estoppel, necessity, ratification, agency of holding out. For 76 the correct answer would be option B. Which of the following is a void contract? So which is not enforceable by law, we all know that it is a void one. So option B would be the correct answer. So question number 78 talks about the proper order. First there would be an offer, then contract. Here it is a we can see there is a spelling mistake, I think, for which an extra grace mark will be avoided, but that is left to the discretion of the commission. We can't reserve any opinion regarding this. So the correct answer would be option D. If we closely see the section 2 of Indian Contract Act. Now question number 79 talks about agreement without consideration is always valid. No, it is not. Now all contracts are agreements, but all valid agreements are not contracts. So the correct answer to this question number 79 would be option C. So option 1 is incorrect and statement 2 is somehow correct. Now question number 80. Statement 1, display of goods by a shopkeeper. Again, this, if I am displaying a goods with a price tag, this is an invitation to offer. Again, the tender, the newspaper advertisements, all are tender, all are invitation to offer. So as per all these statements, the correct answer would be for question number 80 is option C. For 81, what is consent under Indian Contract Act? This is again a very direct question from section 13. The option C would be the correct answer. Question number 82, the Indian Contract Act. Well, this video is getting longer now. I wanted to wind up this video within 45 minutes. Okay, somehow let's start with this, with our venture. Now question number 82 talks about the Indian Contract Act extends to the state of Jammu and Kashmir, Union Territory, it is applicable to whole of India. Question number 83, Hindu Succession Act came into force. Yes, 17 June 1956. Now question number 84, which section of the Hindu Succession Act deals with the order of succession? This is option B, section 9 of Hindu Succession Act. 85, section 19 of Hindu Succession Act provides mode of succession of 2 or more heirs. Yes, option A is the correct answer. Question number 86, section 12 of Hindu Succession Act deals with order of succession among agnates and cognates, devolution interest in co-personal property, full blood preferred to a half blood, and overriding. The order of succession among agnate and cognate is given under section 12 of Hindu Succession Act. Question number 87 talks about section 85 of Hindu Succession Act, murder or disqualified. Option B is the correct answer. Question number 88, will means disposition of property which takes effect after the death of the testator. Definitely मला पर ही जन लोकर will टा effective हुए. Question number 89 होची will is liable to be revoked or altered by the जो will କରିଥିବ ସେ ହିଁ ତାର ରାଇଟ୍ ଅଛି ସେଟା ଅଲ୍ଟର କିମ୍ବା ରିଭୋକ୍ କରିପାରିବ ଦ ମେକର ଅଫ୍ ଇଟ୍ ଅପସନ୍ ଏ ଉଡ୍ ଦ କରେକ୍ଟ ଆନ୍ସର. କ୍ୱେଶ୍ଚନ୍ ନମ୍ବର 90, who can apply for revocation of succession certificate? The interested person can. Option A would be the correct answer. Appeal shall lie in case against the order of district judge under the Indian Succession Act. It is High Court. Appeal lies to the High Court. Option B would be the correct answer. Question number 92, the Specific Relief Act extends to this is again a very direct question. Option B, the whole of India. Question number 93, specific relief can be granted only for the purpose of enforcing individual civil rights and not for mere purpose of enforcing penal law. Option A would be the correct answer as per section 4 of Specific Relief Act. 94 talks about when an injunction cannot be granted to restrain any person from instituting and prosecuting any proceeding in criminal matter. Yes, this can be done. To prevent breach of a contract, this can be also done. To restrain any person from applying for an arrest body, this can be done. So all of option D would be the correct answer. D. Question number 95 talks about how the preventive relief is granted under Specific Relief Act by the court. At the discretion of the court by perpetual, at the discretion of the court by injunction temporary. So both. If we refer to section, I think yes, section 36 of Specific Relief Act, there you can find that temporary injunction and perpetual injunction, it is upon the discretion of the court. Some people may confused it with that key temporary injunction is only be governed by CPC. That's why the perpetual injunction is to be only granted as per the discretion of the court. But section 36 is very clearly states that both perpetual and temporary injunction, it is upon the discretion of the court. Now question number 96, the specific performance of a contract shall be enforced by the court subject to the provisions of the Indian Contract Act and subject to the provisions of, yes, this is option C is the correct answer, because specific performance of a contract can only be granted with reference to section 11 subsection 2, that is trustee in excess of his power, and section 14 and section 16 of the Specific Relief Act. Now question number 97 talks about any person interested in a contract may sue to have it rescinded, and such rescission may be adjudged by the court in which where the contract is unlawful of cause not apparent on its face and the defendant is more to blame than the plaintiff. Yes, this is also true as per section 27 and of Specific Relief Act. Now option B also is true, that where the contract is voidable and terminable by the plaintiff. So both A and B are correct. Option C is the correct answer. Now question number 98 talks about injunction are such as are to continue until a specific time. For a specific time, it has to be a temporary injunction. Perpetual injunction is decided after the through a decree after going through the details of the case. So question number 99 talks about whether any appeal is allowed against the order or decree passed in any suit instituted under section 6 of Specific Relief Act. No appeal, no review lies as per section 6 of section 3 of Specific Relief Act. So option B would be the correct answer. Now question number 100, a plaintiff instituting a suit for the specific performance of a contract in writing may pray in the alternative that if the contract cannot be specifically enforced, it may be declared as unenforceable, it may be rescinded. Again, it is a very direct question as per section 29 of Specific Relief Act. The correct answer would be option B. So with this, let's conclude our today's session, and at the cost of repetition, I am again telling you, those who have these answers keys which was discussed and which we think as proper is purely tentative, provisional and suggestive in nature. So I am telling you that at the cost of repetition that those who have secured more than 35 or below 40, and prima facie they are not, you think that you will not get through this prelims examination. I would recommend you to that not do not stop your preparation for mains examination. Start your preparation, keep on preparing for the mains examination. We never know that how OPSC would respond to this question paper, and what is the correct answer key for all these questions. And there are as per set A, question number 28 and other questions which we see that having errors, and all of those aspects are there. If there is no valuation, if there is any not valued answer, you will be allowed or awarded marks irrespective of the fact that whether it is true or false. Just because you have attended the question and the question is wrong, you may get the advantage of that. So without wasting any time, kickstart your preparation, start preparing, join any test series batch or any test series mock tests. It will definitely help you while appearing in the examinations, because it is the mains examination which will ultimately decide your rank in the exams. So with this, let's conclude our today's session. And if you have any query regarding our upcoming Agni Pariksha batch, you can simply call on this number which is given to you in the very inception of the lecture, or you can post your comments below the video. We will definitely try our best to reach out to you. So with this, let's conclude our today's session. Thank you and have a very good day. All the best for your future endeavors. Thank you.